Leveraging Inspiration, the Inspired Patent Podcast, where we explore the world of innovation, creativity, and intellectual property. I'm your host, Wayne Carroll, and I'm excited to bring you insights and stories from inventors, entrepreneurs, and experts in the field. Today, we're talking about whether you can use trademark terms as keywords in advertisements. So the keywords are what's behind the computer, what the advertising platform, Google, Yahoo, Bing, whoever you are advertising with, what triggers your advertisement to show up. And we've discussed some cases. We've been going forward in time, starting in the past 2000s, early 2000s, and we're coming up to date. We discussed a case in 2009 in the last episode, and now we're going to discuss some more recent cases. We've discussed what the Second Circuit Appeals Court, Federal Appeals Court, which is over in New York, or at least that's part of what they cover is New York, and what they've had to say about trademark infringement using keywords. And now I'm going to discuss for a minute a case on the other side of the country in the Ninth Circuit, which covers California and some other Western states. But before we get started, I want to make it clear that while I'm an attorney, the information I provide on this podcast is for educational and informational purposes only. I am not providing legal advice. Nothing in this podcast should be construed as creating an attorney-client relationship. In 2011, the Ninth Circuit Court of Appeals covering California reviewed a case where one company purchased a keyword of the competitor. And the court said, when we examine initial interest confusion, the owner of the mark must demonstrate likely confusion, not mere diversion. When you purchase a keyword, you're hoping if somebody types in a brand, so I don't think Adidas and Nike are purchasing each other's terms. Maybe they are, but I think they rely on other branding methods. But if you typed in Adidas and an ad for Nike showed up, that you aren't going to be confused because the brand Adidas well enough to know it's not Nike. And that's diversion. And that's what ads hope to do is when you're headed one way, hey, look, I've got a better solution over here. Come over here. This court also said the default degree of consumer care is becoming more heightened as the novelty of the internet evaporates and online commerce becomes commonplace. So one of the things, and this was 2011 when they said that, that's now more than 10 years ago, trademark infringement analysis is changing all the time because the marketplace and the consumers are changing all the time. Unfortunately, that's one of the realities of trademark law. It's hard to easily rely on past cases and the facts of their case to say, my facts are just the same, because the consumer's experience in 2011 is not the same consumer experience they're going to have in 2024. What their understanding, their purchasing habits, their browsing habits, their shopping habits, it's all changed. COVID really changed things. And now we're a few years past COVID. And that's one of the key lessons really in all of this is you need to understand trademark law if you are going to be using your competitors' trademark terms in any way, even in keywords. Your competitors are going to figure out if you're heavily purchasing their keywords and they're a big enough brand that people are searching for their trademark term. They're going to figure it out. There was a case where that's exactly what happened. This was here in Arizona where I'm practicing out of, and I service people and I help people all across the United States and even other parts of the world. I focus on federal law with trademarks and patents. I'm working with clients all across the country all the time. But this one was here locally. Two attorneys went to battle over trademarks. If you're local in Arizona, you've probably heard these two companies, Lerner and Rowe versus ALG, Accident Law Group. The court said, in the keyword advertising context, the likelihood of confusion will ultimately turn on what the consumer saw on the screen and reasonably believed given the context. Accident Law Group was the one purchasing Lerner and Rowe. When somebody had heard 1,000 Lerner and Rowe's advertisements, it's been drilled into their head because they've seen it, they've heard it over and over. They've heard the jingle. Their advertisement is succeeding. Someone's in an accident and they're saying, I should get an attorney. And the Lerner and Rowe ad pops into their head. So they type in Lerner and Rowe, and an Accident Law Group advertisement pops up because they purchased the keyword. Is that trademark infringement? The courts, when they've been talking about keywords, some of them have been just saying, let's just focus on 3 factors. And there was a case that said that, and then people were really starting to follow that. The district court here in Arizona said that they said this case is a good example of consumers looking an ad that's clearly labeled an ad. And by this point, people should know. And oh, by the way, this is a case was issued in 2023. In 2023, people know that the top results on Google, that they've got the word ad, you can distinguish between the advertisements and the organic search results. And they also know that people are working hard to get theirs to always be the top search results. It's all part of a game of trying to get at the top, and you can pay to get at the top, or you can work on optimizing to get to the top. And people know that. Enough people know that the vast majority of the people are not going to be confused. So this case, once again, there's something called initial interest confusion. And they say that the owner of the trademark has to demonstrate likely confusion, not mere diversion. With Lerner and Rowe's advertising, they've done a really good job, and people have it in their brains and they type it in. And Accident Law Group is allowed to offer them an alternative as long as they're clearly understanding that's an alternative. And sometimes they are able to divert people at that point where they're about to click and make contact about their case. This court used a computer store analogy. If you walk into a computer store, if you can find one that's still open, and ask for a Dell computer, and you're directed to the Lenovo counter by the salesperson who says, Dell is great, but have you considered Lenovo? And that's because the salesperson gets a higher commission if they sell a Lenovo than if they sell a Dell. And the court felt like that was a good analogy to what's happening. Somebody's showing up to the store, which is the internet, and asking Google, which is the salesperson, saying, oh, I'm interested in hiring Lerner and Rowe. And Google, being the salesperson, says, have you considered Accident Law Group? So the court felt like that was a good scenario. Now, when these cases come out, other people say that reasons why that's not a good scenario. And then other cases, attorneys are trying to say that doesn't apply in our case because the facts are different, or it was a bad analysis. The court dismissed the case against Accident Law Group, saying that Lerner and Rowe did not present evidence that consumers were confused. And once again, this was at an early stage, and the Lerner and Rowe, according to the court, didn't give enough evidence that there was a likelihood that people would be confused. And that is what this all comes down to. We've been talking about over the last hour is, are consumers likely to be confused? And what happens with a brand? Your brand isn't what you put out. It's what consumers think. If consumers think you have a good brand, that's when you have a good brand. If consumers are repulsed by your brand, then that's where your brand is at. It's not what you say about your brand, it's what your customers and your potential customers, the consuming market, is saying about your brand. Now, the goal of trademark law is that what you are saying about your brand gets to be the impression that people get for your brand. And if you are confusing people, if you are talking about your competitor's brand and then muddling it and talking about your brand and not letting the customers clearly know that you're no longer talking about your competitor's brand, that's where confusion and trademark infringement happens. Even though traditional trademark law, you're selling a product and it's got a brand on it, and your competitor says, that looks like my brand. It's too close. It sounds like it. People are thinking it's similar. And then the court does their analysis and says, yes or no. Now we've moved on to, what if you're just triggering ads when somebody uses your competitor's trademark? You're not putting it on the products. You're not selling products with a brand name that's similar or the same. But the question is, are you confusing people? If Accident Law Group had put in the text of their ads, learner and row is the way to go, which is one of their phrases they say over and over in their advertisements, and that link went to Accident Law Group's website, I'm sure that would have been an absolute difference outcome here in this case. But they didn't do that. They offered ads that were clearly for Accident Law Group and not for Learner and Row. So in this case, Accident Law Group won after going through the hassle of a court case, and that's the risk you take. There haven't been enough cases that it's really clear whether or not you're going to be successful in a trademark infringement lawsuit. And this goes both ways. If you are a brand and somebody's purchasing your keywords, you got to look carefully at the facts. And if you're going to hire an attorney to go after it, they need to make sure they differentiate and make sure they don't do what Learner and Row did and not give enough factual reasons why consumers are confused. And maybe there weren't enough reasons, or maybe their attorneys just didn't get it right. It's hard to tell, but the end result is, if you use a competitor's keyword in your advertising, you might still get sued. If you do it right, you might win that lawsuit.
Business where from a couple of people to however many people you are now, those kind of challenges, have they evolved? Because clearly now you've got it sounds like